Unit 3, Part 1. Let's carry on. So the rules of a medical scheme. Now we're going to look at the learning outcomes which you all need to know for this unit. You need to understand the importance of the rules of a medical scheme. You need to explain the management of a medical scheme. You need to define the relationship between a medical scheme and its members. You must know the rules of a medical scheme concerning the benefits and benefit options, the personal medical savings account, the payment of contributions, and understand the manner in which complaints and appeals are dealt with in the scheme rules. Now we're going to look into each one of them in more detail in this unit. So just the introduction to Unit 3. A medical scheme is bound by its rules, and together with the Medical Schemes Act 131 of 98 and the regulations to the Act, they govern the internal environment of a medical scheme, which includes A. How the daily affairs of the scheme must be managed. B. The obligations of the scheme to its beneficiaries, members and dependents. C. How the financial affairs of the scheme must be managed. D. How the scheme must conduct its business. So if you look at the importance of the rules of a medical scheme, Section 32 of the Act states that the rules of a medical scheme, including any rule amendment, are binding on the medical scheme itself, its members, and its officers, and on any person, even a healthcare provider, who claims benefits under these rules. So even the doctors or the dentist or who claims a benefit, who claims, they also must bind to these rules. The Medical Schemes Act 1998, Act 131 of 1998, it provides for several issues to ensure a clear understanding of the relationship between a medical scheme, its members, and stakeholders. These provisions give effect to the intentions of the legislature in a transparent manner to prevent unfair discrimination and protect the interests of their members as well as the medical scheme. Accordingly, reciprocal rights and obligations are observed in this regard. Once approved and registered, the constitution of the scheme is legally binding on the scheme. The member and his or her dependents and any other party who has a right in terms of this contract and within the framework of the business of a medical scheme defined as follows. So basically this is the definition this here. Now let's have a look at it. It says the business of undertaking liability in return for a premium. So that if they undertake a liability in return for a premium or a contribution to make provision for the obtaining of any relevant health service, to grant assistance in defraying expenditure incurred in connection with the rendering of any relevant health service, and where applicable, to render a relevant health service either by the scheme itself or by any supplier or group of suppliers of a relevant health service, or by any person in association with or in terms of an agreement with a medical scheme. Governance of medical schemes vests with the Board of Trustees with fiduciary responsibilities and accountability to the members in terms of the trust principle, as medical scheme funds can only be applied for the benefit of the members as the only share owners. Medical schemes are accordingly restricted in terms of what they can lawfully do and may not engage in other business which falls outside the framework of the definition of the business of a medical scheme, while managed care arrangements and general contracting out of service are done to ensure that members are provided with the cover they need. The purchasing of commercial insurance for benefits is subject to prescribed requirements and procedures. In order to perform these duties and to manage the scheme in terms of its constitution, schemes are entitled to access information of members for a variety of reasons. Members of medical schemes must similarly provide accurate information at all times. Schemes have extended rights to suspend and terminate the membership or participation of dependents due to failure to disclose material information or provide false or misleading information. That can cause big troubles at the end of the day if you're not open or you don't disclose. Confidential patient information must be treated as such, as confidential, obviously, and can only be parted with and disseminated to a third party with the consent of the member. Can I get the consent afterwards? Those of you who says afterwards, yes. Or must I get it before? What do you see? Is it A or B? Can I get the consent afterwards or before? Those who said afterwards, with your hands up in the air, you are all wrong. Nah. You must get consent before. Then you can let the information out, not afterwards. Information to be supplied by members relate to primarily to the following: the full details specified in the application form of the family member, including the details of healthcare treatment obtained during a specific period and a bona fide statement as to the legitimacy of dependents so declared. The rights to the benefits of the scheme upon submission of valid claims for healthcare services legitimately obtained by the member and his dependents, disclosure of information required by the scheme to ensure compliance with the Act regarding the application of waiting periods, details of income where relevant and changing circumstances are affecting the status of dependents in terms of the scheme rules. Members furthermore should pay the relevant contribution which entitles them to have access to the benefits and the rights flowing from the legal relationship with the scheme and summarized as follows: the right to continued membership of the scheme after retirement resulting from either age or ill health, right to access information based on demonstrated interest, the right to lodge valid complaints and disputes to an impartial tribunal, and the right to attend member meetings and to vote thereat. It includes the right to participate in the election of persons to serve as trustees of the scheme. So you as a member of the scheme can vote for the trustees of the medical scheme. Who do you want as a trustee of your scheme? A medical scheme is prevented from applying unfair discriminatory measures against members. Applicants may not be refused or penalized when admitted to open schemes other than in the prescribed manner, and contributions may similarly not be determined on group participation, age, state of health, gender, race, geographical circumstances, or any other manner. Contributions may only be determined based on the income and or several dependents of the member. You see, so contributions you can only based on the income of the member and on the dependence of the member. So the more dependents you have, the more you're going to pay. while waiting periods and late joiner penalties are the only measures applied to avoid adverse selection against schemes when members move between schemes or when persons are admitted without previously demonstrated membership. Employers do not become legal parties in terms of the scheme or the member relationship to the extent that employers subsidize contributions of their employees and may assist with the payroll management and payment of contributions to medical schemes. They would do so as a participating party or conduit. Any subsidy paid by an employer to a medical scheme vests with the scheme and refunds thereof or repayments to employers for any reason is without legal foundation. The broker fraternity is recognized in this relationship provided such person or organization is accredited as required by law and they comply with the prescribed requirements throughout. So the following measures are of particular importance. The broker is recognized as the agent of the member, and the member is not compelled to make use of broker services in obtaining membership of a medical scheme. Medical schemes may accordingly not allocate members to a broker for purposes of providing broker services and remunerating such brokers. The broker is entitled to a maximum prescribed fee as remuneration from the scheme in respect of services rendered to a particular member, but no distinction in fees is permitted based on inflated remuneration to attract only groups or reduced fees payable in respect of certain or more vulnerable groups as a disincentive. So they cannot base the commissions on, they must only bring young people or they get less if they bring older people. And we've already looked at the commissions which the brokers are allowed to receive in the previous unit. Alternatively, to allow splitting of risk in a manner that is harmful to groups of members and specified schemes. Brokers cannot observe. Observe means to seize or to take over. They cannot seize or take over the powers, the rights and obligations of the member as it relates to the signing of documentation, application forms, the resignation of membership, and the like, nor can they attend member meetings on behalf of the member. So if the member cannot attend the meeting and they want to vote for a trustee, they cannot send the broker. No. The moral rules serve as a guide to stakeholders for complying with the Act, the regulations framed thereunder, common law provisions, sound corporate governance practices, and various internal policy decisions, which provide clarity on matters affecting the relationship between the scheme and the member in a practical manner. The main objective is to provide a consistent sequence of logical rules which govern the legal relationship between the medical scheme and its members. As indicated before, this document is dynamic and will be modified from time to time. This version incorporates the latest amendments to the Medical Schemes Act and regulations which came into force on 1 January 2003. So we looked at all the important rules and now we're going just to look at the normal rules of a medical scheme. Various sections of the Act sets out the specific matters for which the rules of a medical scheme must provide. These include the following: the appointment and or election of a board of trustees to govern the scheme, the appointment of a principal officer by the board of trustees, the removal of officers, the manner in which complaints and disputes are to be settled, the terms and conditions applicable to the admission of a person as a principal member and his dependents, the scope and level of benefits and the scale of tariffs for the payment of benefits. Section 29 and 30 deal with matters that could be or should be included in the rules of a medical scheme. Section 29, subsection 1 prevents the registrar from registering a medical scheme unless its rules provide for A, the appointment or election of a board of trustees consisting of persons who are fit and proper. We always note they must be fit and proper to manage the business of the medical scheme. Section 57 stipulates that 50%, so half of the members of the board of trustees, must be elected amongst members. So that must be members of the scheme. So half of the trustees must come from the members of the medical scheme. It does not stipulate any minimum or any maximum number. So they can have 5 trustees or 20 trustees or 30. There's no minimum or maximum. Section 57 also prohibits a person from being a trustee if that person is A, an employee, a director, officer, consultant, or contractor of the company, subsidiary, joint venture, or associate of that administrator, or B, a broker. Section 57 states that trustees must take all reasonable steps to ensure that the interests of members in terms of the rules of the medical schemes and the provisions of the Act are protected at all times. Act with due care, diligence, skill, and good faith. Take all reasonable steps to avoid conflicts of interest and act with impartiality in respect of all members. More specifically, the duties of the trustees are as follows. Section 57. To appoint a principal officer who is fit and proper to hold such office. To ensure that proper registers, books, and records of all operations of the scheme and proper minutes of all resolutions passed by the board are kept. To ensure that proper controls systems for the scheme are in place. To ensure that adequate and appropriate information is communicated to members regarding their rights, their benefits, contributions, and duties in terms of the rules of the scheme. To take reasonable steps to ensure that contributions are paid timeously to the scheme. More specifically, the duties of the trustees are as follows according to Section 57. To take out and maintain an appropriate level of professional indemnity insurance and fidelity guarantee insurance, to obtain expert advice on legal, accounting, business, or any other matters on which the board does not have expertise as required, to ensure that the rules, operation, and administration of the medical scheme comply with the Act and all other applicable laws, and to take reasonable steps to protect the confidentiality of medical records concerning a member's state of health. In terms of the Act, the trustees are responsible for preparing annual financial statements for the scheme within 4 months of the end of the financial year. And these statements, together with an annual report, must be submitted to the registrar according to Section 37. So, the financial statements for the scheme must be given to the registrar within 4 months from the end of the financial year, and these statements, together with an annual report, must be submitted to the registrar. The registrar may also request quarterly returns. So you see, he may request quarterly returns, and in practice does require quarterly statements. So if he wants quarterly returns, then he also wants quarterly statements, as this assists the registrar to detect any financial problems at an early stage. So instead of him waiting every year, annually, and he thinks that he suspects there's problems, he can request your financial statements and returns every quarter. And B, the appointment of a principal officer by the Board of Trustees who is a fit and proper person to hold such office. The Act does not prescribe the duties of the principal officer, but the CMS has drawn up a set of model rules for medical schemes. Rule 20 of these rules broadly sets out the duties and functions of the principal officer. The principal officer is essentially responsible for the day-to-day running of the business of the scheme. Section 57, subsection 7 states that the principal officer of the scheme may not be an employee, director, officer, consultant, or contractor of the administrator of the medical scheme concerned or of the holding company, subsidiary, joint venture, or associate of that administrator, a broker or an employee, director, officer, consultant, or contractor of any person contracted by the scheme to provide broker services, an office bearer of another medical scheme, or someone who has a material relationship with any person contracted by the scheme to provide administrative, marketing, broker, managed healthcare or other services, or with its holding company, subsidiary, joint venture, or associate. See the appointment, removal from office, powers, and remuneration of officers of a medical scheme. D. The manner in which contracts and other documents binding the scheme shall be executed. E. The custody of the securities, books, documents, and other effects of the scheme. F. The appointment of the auditor of the scheme and the duration of that appointment. And G. The power to invest funds. H. Subject to the Act, the manner in which and circumstances under which a medical scheme shall be terminated or dissolved. I. The appointment of a liquidator in the case of voluntary liquidation. J. The settlement of a complaint or dispute. And K. The amendment of the rules in accordance with Section 31. Section 31 provides for a scheme to amend or rescind any of its rules or make additional rules in the manner provided for in the rules. It also states that no rule change will be valid unless it has been approved and registered by the registrar. So, whenever you want to change benefits or benefit options of scheme rules, it will not be allowed unless it has been approved and registered by the registrar. So you must send those things into the registrar to get them approved and registered. In practice, most schemes amend their rules when they change benefits and contributions at the end of a year for the new year ahead. The registrar now requires a scheme submit these changes by 1 October each year, so that he's got enough time to work through all them that they are registered and approved before the end of the year, so they can kick in on the 1 January the next year. Section 32 states that the rules of a medical scheme are binding on the scheme, its members, officers, and any person who claims any benefit under the rules, or any person whose claim is derived from a person who claims under the rules. L. The giving of advance written notice to members of any change in contributions, membership fees, or subscriptions and benefits or any other condition affecting their membership. That's the end of this unit. If you've got any questions, you know what to do.